I hope I don't disappoint you. As you just heard, I published a book about the matters that I'm talking about tonight, which in German was called Der Dienstbetrieb ist nicht gestört. The original title was supposed to be The Administration of Normality. I had to change it because of the publisher. They wanted to have a different title, but the event of tonight, which I dared to call The Administration of Normality, is actually the original title of this entire research project that kept me busy for more than 10 years of my lifetime. And in case there's anybody who already had a look into the book, it may be disappointing because I didn't do any research after the book. So this is, I don't want to say I'm just repeating what's in the book. But this was sort of the core of my research, and so I guess there won't be too many surprises tonight. The idea of this entire project was to write a social history of Germany around the end of the Second World War, roughly around the year 1945. I chose a bit of a different chronology and then chose the years 1943 to 1948. There were several reasons why I chose to do that. We can talk about this maybe later. I'm not going to get into details now. More important is that the idea was, the concept was not to depict all the abnormal aspects of this time, so not the genocide, not the Shoah, not the war, not the violence, the entire Gewalt, the final mass violence of the regime. So not to focus on those aspects that actually separate us from this part of history, from the end of the war, and what, despite all the empathy that we have for the victims of National Socialism, ultimately create historical distance, but on the contrary, to describe what connects us with National Socialism, the normal life, things that we have in common, reflected and processed here through the means of the law. So to speak, the bottom, the sediment of the legal system. All those matters that usually seem unexcited and unpolitical, normal, but that only receive their noteworthiness by their context because they occurred in these extreme times. So I took examples from tenancy law, from matrimonial law, insults, minor physical assaults, all those cases that meet something like a routine objectivity in law. The aim was to describe how even the most brutal state of emergency needs something like a rule in order to gain form, to gain shape. That is how to take up Ernst Fraenkel's famous dichotomy, how the normative state supports the prerogative state, even where the normative state doesn't do anything else but simply administering the daily routines. So the prerogative state, the Maßnahmenstaat, cannot do without the normative state. To put it in a paradox, even lawlessness needs a form of law. So how is normality administered in a time that neither the contemporaries nor we in retrospect would perceive as normal? The first abnormality that had to be dealt with was the war with all its destruction. In 1943, at a time when the war was arguably lost, Goebbels proclaimed total war, and now even civilians at home were considered part of warfare, not of the military front, but of the home front. And in June 1943, just to give you an example, the High Command of the Wehrmacht issued instructions that civilians were also in military action at home during air raids. And so casualties among civilians at home should therefore also be designated as wounded or fallen. So they were adopting the military semantics, even at the home front, to civilians. And correspondingly, the law also became part of warfare. Its duty was to keep the home front calm, to show that everything was under control, to set an example in strength, in composure, and in heroism. Time and again, judicial officials, judges, prosecutors were reminded that they had to serve just as dutifully as the German soldiers on the war front. As civil servants, they owed, and that's a quote, loyalty to the Führer in good and bad days, which sounds like a marriage vow in a way. In service, they were asked to develop a soldierly attitude and reminded that no hostile threat, no terror, and no destruction, neither personal concern nor personal loss, should make them slacken in the performance of their duties. That's obviously also a quote. Even after a major air raid, measures always had to be taken to ensure that one shall pursue as much as possible the undisturbed continuation of judicial business. In addition, a huge number of decrees, circulars, and service instructions were issued, all with the aim of maintaining legal operations by all means. The court records had to be secured. In case they burned, they had to be restored. If the typewriters were destroyed, you had to get new ones. If the buildings were burned down, you had to move to another building. If the town you were in was occupied, you had to move the court to another town. If the staff had been killed, you need other staff. A permanent deployment and reporting system was recommended so that suitable members of the judiciary could be called upon immediately to take part in firefighting and cleanup work. Those who could not be notified by telephone were to report to the court at 6 a.m. the morning after the attack. In July 1943, the Reichsministry of Justice in Berlin issued a detailed overview called Air Protection Measures in Government Buildings. Water, sand, and letters should be kept ready. Land registers and other valuable records should be secured or, if possible, photocopied. Firm, purposeful leadership and a good organizational overview were declared decisive in the event of an emergency. Even unpleasant details offered useful experience. That's a quote, "Fires must be fought from close up and from below." Larger bags were useful for salvaging records, was noted, and it was a good idea to form a chain in the case of heavy stacks or imminent danger. The cleanup work should be tackled during the fire, particularly because water damage was usually much greater than fire damage. Additionally, prisoner squads could be called in to clean up. Courts that had followed these rules were able to carry out legal services on the day after the bombardments without any significant impairments. The same month, July 1943, the so-called Operation Gomorrah hit Hamburg and more or less destroyed the entire city center. Again, the authorities informed that water and sand supplies were necessary, as well as good fire brigades. Uninterrupted salary payments and communal meals for the cohort were also important, and if possible, emergency accommodation should be offered. However, even after these severe attacks, with more than 30,000 people killed, experience shows that, that's a quote again, individual parties and witnesses come to hearings, which is why court services must in any case continue uninterrupted as an emergency service. It is decisively reassuring if the public notices that the courts did not let themselves get rattled and continued their work. In Hamburg, all court buildings were kept operational in this way. In particular, it was thanks to the energetic intervention of the firefighting teams that court services never came to a halt, not for a single day. End of quote. This was not only the case in Hamburg, it can be observed everywhere in the German Reich. Even when the large-scale Scarpet bombing had showered down on German cities in the summer of 1944, the civil servants acted as was expected by them, dutifully, obediently, and ready to make sacrifices. In the last months of the war, there was an attack somewhere or another almost every day, and judicial buildings were almost always affected. Total war ate its way through the entire German Reich. But hardly any of the reports about these bombardments lacked the defiant closing formula at the end: legal services were maintained. Now here's a small selection. I had to leave out many cases, otherwise it would be a bit too much. Another large-scale attack on Hamburg in August 1944 partially destroyed the higher regional court, the Oberlandesgericht. The sheer weight of the bombs penetrated all floors, in addition to time fuses that continued to detonate long after the attacks. Some court hearings had to be cancelled, but in general, the course of justice was never impeded. In Königsberg, Kaliningrad, the entire city center was destroyed shortly thereafter. The higher regional court burned out completely and all records were lost. At the local and regional court, where the fire had spread only to the upper floors, the homeless judicial authority found shelter. The immediate judicial service also took place there. It seems to me worth mentioning, the court president concluded his report, that the next morning at 9 o'clock, that is 7 hours after the end of the attack, a criminal chamber held a session in the building which was still partly on fire, in which 4 out of 5 cases were heard. The destruction of Stuttgart in the south of the German Reich in September 1944 was even more devastating. Practically no building in the city center was spared. Fires broke out everywhere, and the supply of water, electricity, and gas came to a halt. 9 huge explosive bombs and numerous other explosives fell upon the large judicial building, the seat of all Stuttgart's courts. Records and books were destroyed almost without exception. Nevertheless, it was not without pride that the Attorney General was able to report to Berlin that on the morning after the attacks, still in plumes of smoke, a number of criminal trials had already been held in the few considerably damaged rooms still available. In Detmold, in the very west of the Reich, the regional court lost all of its window panes in an attack on New Year's Eve. But this was no reason to interrupt legal services, even in winter. Business went on as usual. The local court in Ahrweiler also had no windows and no heating after an attack in early January 1945. 2 ovens ensured that the most urgent work could nevertheless get done. At the local court in Hillesheim, where work had already been going on for weeks without light, water, telephone, post, and transport links, windows and doors were also destroyed shortly afterwards. So now they basically had nothing left. Here, too, the court was able to defy the winter cold and continue its work. During the attacks on Vienna on January 15, 1945, one of the 2 court buildings was almost completely destroyed. In the other, which had lost all of its windows, legal service continued immediately. The hearings scheduled for the following day were held without any problems. After an attack in Rheinbach, the 5 undamaged rooms had to be shared with a nursery home, and the supply of light, water, and gas was interrupted. Nevertheless, legal services continued as far as it is still possible. At the Osnabrück Regional Court, the demolition bombs had not left a single room undamaged. 6 days later, the standard news followed. Legal services have resumed in the heavily damaged buildings. In Bensberg, on the right bank of the Rhine, it was even worse. There was not one undamaged room left, not to mention a huge hole in the outer wall, and the building was also under constant artillery fire. But here, too, it was true, regardless of losses, legal service will be maintained to a large extent as long as it is possible. At the local court in Schwäbisch Hall, and now we are entering March 1945, all windows and some doors were lost, and numerous buildings in the surrounding area were destroyed. The front window received cardboard panes, and the reporting said legal services continue for all judicial authorities in Schwäbisch Hall. At the same time, the 3rd major attack in Leipzig had left devastation in its wake. The Reich Supreme Court, Reichsgericht, was also affected. The president's apartment was destroyed, and from then on he lived, along with a fellow judge's family, in the basement of the house. However, legal services continue without restrictions. In Reutlingen, again in the south, the firefighters ensured undisturbed legal business. Their energetic intervention kept the fires in the vicinity away from the courthouse. A firebomb in the roof was immediately extinguished. The continuation of legal services to the previous extent is assured. In Göppingen, again in the south, it was the judge himself who lived in the court and was able to extinguish a firebomb immediately after the attack. Therefore, legal services in the local court are not disrupted. And from Ulm, which the Attorney General declared to be now completely destroyed after several attacks, came the usual proviso: the business of the public prosecutor's office was not interrupted. That is now April 1945. Lack of space, loss of records, cold darkness, and on top of that, death. In Bonn, the judiciary resided on a pile of corpses after the large-scale attack of January 6, 1945. The public air raid shelter located under the court received a direct hit, and well over 200 people were killed. Gas, electricity, and water were out for several days throughout the city. The judges moved to the neighboring building of the local court, where they took refuge in the air raid shelter. The smell of decay must have been everywhere. According to the precautions taken, the report concluded, the maintenance of an orderly judicial business is assured, and so on and so forth. I said I shortened a bit. Maybe it was still too much. I hope you aren't bored in the meantime. These reports about the heroism of one's own performance of duty were interest-driven, of course. Everybody wanted to depict himself in the best picture possible. But their very number speaks against the fact that they were greatly exaggerated. Moreover, the authors of the reports could count on confidentiality. Mostly, these reports were classified as a geheime Reichssache, so to open them would mostly cause a death sentence. So there was little reason for whitewashing these reports. And so it seems that all these legal soldiers, all these judges of the Führer sat in their offices in early 1945 and did their duty. Old, most of them, because the young ones had to go to the Wehrmacht, frail, damaged, bombed out, cut off from their records, from their books, from their prisoners, often freezing due to the smashed windows and to the rationed heating, sitting at unlit desks to save electricity, aimless in their industriousness due to missing paper and to missing typewriters. In Saarbrücken, the courts worked only in shifts during the day so that merely a portion of the judicial staff would be exposed to the dangers of the constant attacks. In Eisenach, negotiations continued in the air raid shelter when the air raid alarm sounded, even though this led to conflicts with the other shelter seekers who complained about losing their seats. The chief public prosecutor in Stettin complained that his 59 staff members had just 12 rooms at their disposal and that some of them had to work in the corridors without lighting. From Zweibrücken, it was reported that the judges would alternately spend one day working at the Siegfried Line to secure the military front and one day doing their official business. In Cologne, the last departments of the public prosecutors were moved to the detention rooms in the basement after the air raids of February 1945. In Koblenz, they moved into 2 rooms in a bunker, and in Cochem, legal services continued in the judge's private apartment. People met anywhere to administer law, martial law, emergency law, improvised law, normal law, just any law, to decide on the last land register entries, alimony suits, divorces, neighbor disputes, insults, thefts, lootings, violent crimes, and whatever the whims of chance brought into their offices. In Hanover, in the days before the end of the war, the local court dealt, among other things, with a senior post office clerk who had accused the police of dirty tricks, foul play, and corruption during a police check. The local court sentenced him to a fine of 500 Reichsmark, I guess about 5,000 euros today. A marriage swindler, on the other hand, was sent to prison for 8 months. He had forged his passport in order to appear younger and more desirable, and through this had obtained bread and butter and a dinner worth 10 Reichsmark from a chance acquaintance who was willing to marry. They had actually met at a subway station in Hanover. The Hanover court last convened on April 6, 1945, the day US and British troops entered the city. The Freiburg local court held its last session on April 19, 1945, and the parties met to negotiate the modification of a judgment of support. The divorced husband claimed that his ex-wife was now able to work again, that he himself had also remarried, that he had to take care for a child brought into the second marriage, and that he had now also taken in his mother. Instead of 130 Reichsmark per month, he wanted to pay only 60 Reichsmark. The court ruling was set for April 24th, but could not happen because 2 days after the hearing, French troops entered Freiburg. The small local court in Kirchheim, again southwest, also met for the last time on April 19th. A farmer named Schmidt had sued his daughter-in-law, who had moved into Schmidt's house in 1937 with Schmidt's son. The son was supposed to work for his father, so they had agreed on a modest monthly rent of only 10 Reichsmark. but the sun had fallen at the front in September 1943, and now the father was stuck with the daughter-in-law who did not work for him and lived with him far too cheaply. In March 1945, his lawyer sued for a rent increase. At an opening hearing on April 12th, the defendant agreed to an increase in rent to the amount of 20 Reichsmark. Schmidt, however, wanted 25, and therefore the remaining 5 Reichsmarks still had to be decided. On April 19th, the day of the next hearing, the Americans were already in the neighboring village. The judges showed up in court, but the parties had decided to stay at home. In Stralsund, in the northeast, the last case dealt with was the theft of a bicycle. The defendant, a refugee from the east, claimed he had to leave his own bicycle behind in his hometown and therefore asked for lenient punishment. Legally, obviously, that's irrelevant. On April 24th, 1945, he was sentenced to 6 months in prison. In Greifswald, the court worked until April 27th, a Friday. The agenda provided for 5 cases of theft, receiving stolen goods, and breach of labor contract. 3 days later, the Red Army moved into the city. In Dresden, business was as usual on April 30th, 1945. One of the last sessions of the local court was devoted to an ornamental garden in a Dresden suburb. At the end of March 1945, a homeowner had filed a suit against his tenant, whom he had contractually granted part of the garden behind the house in order to plant perennials and create a goldfish pond there. Now he, the homeowner, wanted to grow vegetables there himself, citing the general food situation as well as the unfortunate circumstance that he could not sidestep it for the piece of the garden in front of the house. After all, flowers were already growing there in front of the house, and the vegetable garden would, quote, not exactly contribute to the beautification of the front of the house, end of quote. The defendant, who considered his collection of perennials to be scientifically important, referred to the contractual agreement, in addition to the notion that the garden had always given pleasure, not least to the plaintiff himself. On April 26, 1945, a peaceful agreement was reached. The defendant agreed to clear a 6-meter wide strip in its entire extension of length. The costs of the legal dispute, 2 Reichsmark, were imposed on the plaintiff. So this is the normality of this time that I wanted to describe, an irritatingly familiar picture. All these cases and all these records look exactly the same as they do today, with the same covers, the same bureaucratic order, and arguably the same problems that occur in modern societies at all times. So the example asked for was indeed set. The legal soldiers contributed whatever they could to keep up the order at the home front. The normative state was kept alive until the last days of the war, until the entire justice system looked like a Kantian farce. Fiat justitia pereat mundus, let justice reign, though the world perish, or as Kant put it in his Perpetual Peace, let justice reign should all the rascals of the universe perish. Before the dissolution of the bourgeois society, the last murderer would have to be executed so that everyone would receive what his deeds are worth, and the blood guilt would not stick to the people who did not insist on this punishment. A quote from the Metaphysische Anfangsgründe. The German justice system at the end of the Second World War was only slightly culpable in this respect. The last murderers, the last traitors, the last public vermins, Volksschädlinge, were orderly executed. The last thefts, assaults, and insults were punished according to the rules, and even with the last forms, cash balances, travel expense reports, stamp pads, and service calendars, the war justice system took care to ensure that it could hand over its legacy to posterity free of any blood guilt. In Breslau, Wrocław, marriages were still being divorced at the end of March 1945, when the city had already been surrounded by the Red Army for weeks. It will probably not be surprising to see what happened to this legal sediment after 1945, after the unconditional surrender of May 8th. It has been well known for decades that the unconditional surrender did not bring a radical break for the German society. And again, the way the law rejected any idea of a clear political cut reflects this general societal continuity quite well. The majority of administrative acts, penalty orders, and civil proceedings individually applied for and individually tailored had remained untouched by big politics. What had once entered the legal sphere did not simply disappear from there. As soon as a court had decided to open the main proceedings, a case could no longer be erased without a trace. The dispute then hung in the archive of the law, litis pendens in Latin, a metaphor that is originally said to have reflected an actual practice in the early modern period. The records were hung under the ceiling at the court to keep them safe from mice that would otherwise eat up the paper. In that respect, nothing had changed, although now it was not the hunger of mice that endangered the archive cases, but the course of world history. So when the German judges returned to their offices under Allied supervision, a significant part of their work consisted of finalizing these old cases. Of course, this could not be done without major adaptations. In criminal law, there was no retroactivity anymore. A looter was no longer a vermin, a Volksschädling, but presumably he was still a thief. A defendant would no longer have to fear the decent sentiment of the people, the gesunde Volksempfinden, but he could still be considered an ordinary criminal. The state's claim to punishment was still intact. Even if the sentencing courts now belonged to Poland or to Russia, their legacies still required possession. A number of prisoners from Pomerania were stranded in Bavaria, and the Munich district court now had to rule on their petty thefts from way back then. Most of the sentences were suspended on probation. In Hamburg, the court had to decide on a postal employee who had been sentenced to 3 years in prison by the German court in Warsaw in 1943 for the theft of field post. But in 1948, the Hamburg district court reduced the sentence by only 1 year, so 2 years imprisonment was still considered appropriate. After all, it had to be taken into account that, that's a quote from the ruling, the theft of field post during a war requires severe atonement. And in civil law, as you can imagine, there were far fewer corrections to be made. Like the state's right to punish, the party's desire to fight had come through the war pretty much intact. Broken marriages remained broken. Those who wanted to get divorced could often hardly wait for some institution to finally be available again to take care of freeing them from the marital yoke. Just one example, in Pomerania, a young couple had married in 1943. The husband went off to war immediately afterwards, but returned home unexpectedly from the front in 1944 and told some bizarre stories about an alleged convalescent leave, which a few weeks later earned him a death sentence from the state for desertion and a divorce petition from his wife. After the surrender, only the death sentence, which had not yet been executed, was nullified. The man was released from prison. But his wife insisted on divorce. She wanted to be freed as quickly as possible, quote, from the man who had disappointed her so badly and with whom she could never and would never want to continue the marriage, end of quote. She prevailed. On October 9th, 1946, the Greifswald court dissolved the marriage and found the man solely responsible, as his lie had made it impossible for the woman, quote, to continue to show him the respect required by the nature of marriage, end of quote. So retrospectively, you were allowed to lie to the Führer, but not to your own wife. Other broken contractual relationships were just as broken as before. In the small town of Esslingen, a landlord had started a fight with his tenants in 1938 because they would not clean the yard and the children were loud. In 1944, he had eventually sued them. In 1945, he was imprisoned by the American military government. In 1948, he returned only to learn that he had still not won his lawsuit, although the children were still loud and dirty, and a former Wehrmacht soldier was often seen to visit their mother. Wary of all the bustle, he wrote to the court, "This struggle has now been going on for 10 years already." And of course, by 10-year struggle, he did not refer to the war, but to his own personal fight against his tenants, indicating that he was eventually entitled to a judgment, which actually came in September 1950, but he lost. Tenancy disputes, insults, assaults, divorces, belligerence and vanity, resentment and envy, life returned in all its splendor. In Dresden, a singer from the state opera returned from Russian captivity in September 1945 and immediately resumed his legal battle against a pharmacy that had mixed way too much of zinc chloride into his medication. The singer had lost his voice. The opera had dismissed him in 1944, which meant that in addition to a glittering career, his annual salary of an astronomical 23,000 Reichsmark had come to an end. A final hearing of evidence failed on April 20th, 1945, because the expert witness, and who could blame him, had complained about a lack of the necessary composure. But composure was a rare resource also in post-war Dresden, and so it remained difficult to clarify the facts of the case. The consequences of the pharmaceutical era were probably mainly psychological, and the records of almost everybody involved had been burned. It took another 3 years before the plaintiff finally succeeded. In 1948, he got his ruling from the court and received 44,000 Reichsmark of damages. In Zwickau, 2 former housemates argued about the costs of a move which the defendant had agreed to pay, but the plaintiff had moved her residence at the beginning of 1944 for an almost outrageous sum of 1,600 Reichsmark, 16,000 euros, employed 2 packers for 4 days, and also had everything insured. The defendant wanted to pay half the amount maximum. An epic hearing of evidence continued into April 1945. An expert opinion attempted to clarify the appropriateness of packing costs and tips. It was not until September 1945 that things continued, but then as lively as before. Numerous witnesses appeared, manuals provided information on standard transportation costs. In 1951, there was a judgment in favor of the plaintiff. A year later, a dismissed appeal, and finally, peace. And why not? War is not a legal argument, and neither is peace. The law clings to the political order, to the decrees, ordinances, orders, and laws that the political arena separates out, and yet politics is not a countable currency in legal discourse. In 1947, a high justice official from Hamburg expressed this strange continuity of the legal system as follows. Since the occupying power did not allow a revolution, the German jurist had to logically recognize the continuity of the law, even with regard to the individual legal and administrative act from the past National Socialist era. This legal obstinacy provides a blending mechanism, an instrument to counter the collective state of emergency with an individual state of normality, to dissociate oneself from the fragility of the world and to bring the experienced reality back into its folds. This is not a privilege of the law. Normality has also been preserved in other areas. Countless examples are also known from economics, from religion, from sport, from art, and so on. where a realm of normality had negated the exceptional state of the environment. But law as a normative endeavor is somehow different. The normative nature of law always refers to the future, even if only implicitly. Normativity is the eternal promise that something will happen in the future that has not yet come. This is why law is so wonderfully suited as a place of repression, of illusion, and of cognitive dissonance. The legal actors I met in all these records showed a complete incapacity to synchronize their own reality with the reality of the rest of the world. To a certain extent, the law is always at odds with the times. The post-war period was not the Third Reich, and the new normality was no longer the old one. But the normality of law secured identity in this difference and allowed for the strange illusion that life just went on. Thank you.
So thank you very much for your lecture with these illustrative examples, which I think present very well and support your arguments very well. And any questions? I do have some, but before I ask my questions, maybe there are some questions among the audience. Annika Wienert, Christa Wendt and Herr Luse come. Depending on the question, you may like it out.
Well, I would also have a few questions, but I'll start with one. So the upholding of normality is indeed, we even see that in the German staff in the examination camps. But for court proceedings, isn't it? I mean, for judges and lawyers and attorneys, this is their daily life, their normality. But for plaintiffs and defendants and witnesses, this is usually an extraordinary experience in their lifetime. They don't do that like every day. So how does that? I don't know. Is there any contradictions from that? Do you see cases where defendants just didn't show up, or plaintiffs, or is everybody involved in this upholding?
In this machine, I would say. Well, yes, that's a good point. In criminal law, they don't have a choice. If they don't show up, in the end, police forces will come and take them. And so then they will be brought to the court and will show up. In civil law, they do have a choice. They don't have to bring this lawsuit to the court. And so I was indeed surprised by how many still decide to take this step, which is also interesting because you could read it both ways. The classic alternative to a lawsuit would be, just do it yourself. If you're annoyed by your neighbor, go there and, threaten him with physical violence. And so, of course, as a civilized person, you don't do that. You go to the state. And yet it seems so terribly uncivilized to do that in these times. It doesn't fit into this entire surrounding. But anyway, in civil law, they do have a choice. So yes, I would still consider it as part of normality, although they normally don't do this. But it seems that the problems they bring to the court are sort of day-to-day problems. So yes, there might be a slight contradiction, but in general, I would keep up the argument. There was another point you had. Okay.
Also, I don't think it's a contradiction to the argument, but I think it even strengthens it, that even people for whom this was not a daily normal situation, that they continued to pursue this, whatever cases they have.
Thank you. I was wondering if you found any evidence for an impact of the civil courts in the annexed countries, not in the occupied France, but in the next countries, because there was a quite rich amount of civil courts in these next territories, and when the staff moved into the core Reich, into Germany, can you observe that they are employed in the courts in the central part of the Reich, or had they any impact on how the courts make decisions or how they interpreted the law and so on? So is there, can you see a kind of interaction between the end of the occupation in the annexed territories and the moving of the staff into Germany back, and what happened to them?
In the occupied territories or in the annexed territories, there were German courts because Germany considered it to be a German Reich. And so they established a German court system in all the parts of Poland, of Belgium, of the Netherlands, and so on and so forth. And there you can always find German courts. Some of them very, very unspectacular. I've researched in Belgium for 3 local courts, and it was, I wouldn't say it was so boring because it's still from this time. So it's like, it's a legal source, which I found interesting, but it's because it just looks like it would look today, it seems so boring. And yes, this was a German court. They, in the West, it was not too difficult because there they had Cologne next door, and so they could just take Cologne judges to administer justice in these new courts. In the East, particularly in Poland, it was much more difficult. They tried to set up a justice system in the annexed territories, but it was very, very difficult to find people to serve there. And not because it would have been unattractive, but because the Wehrmacht needed so many soldiers, and so it was just a radical shortage in personnel. And when these people came back to the Reich in 1944 and 1945, mostly due to military events and the ongoing loss of the war, nothing happened. They were just considered German civil servants, and so as a civil servant, you have a right to be employed by the state, and so you look for something else, but there was like no change in discourse. They were applying law there, and now they're applying it here. But I mean, you know, the kind of law that I was researching is tenancy law didn't make much of a difference. I actually wrote one chapter because I found it so interesting about the local court of Auschwitz, of Auschwitz, because they also set up a court there, and this sort of reflects many of the problems of difficulties in finding these people and their fate after 1945, but it seemed to me very unspectacular. And I forgot, I wanted to make, because you asked, I found one example in one record of all these records that I read. In one record, I found a defendant in a tenancy lawsuit, which was about some really a minor aspect. I think it was actually about cleaning the hallway in a huge house regularly, where the defendant said, "Why do we deal this in times of war?" But nobody commented on this because legally this is so absurd. You know, you deal with it because it's the law. Why would you care for the rest of the world? And so this was one example where he actually said this is ridiculous, which is like a very strong word in a lawsuit to be used, but nobody reacted.
Jan?
Yeah, thank you very much for your talk. I have a question concerning the continuities. You made a very strong argument that it seems like business as usual is going on with the same people, dealing with the same cases. Was there any interference in some places, like in the Soviet zone of occupation, French zone of occupation? Do we have the influence or disruption of the system by the occupying forces? I mean, it seems like just a week or two after they resumed their work, as nothing had happened. So how did that look like?
Hard to generalize. In the Soviet occupation zone, it was different, but it was not totally different. It was different in all these political aspects. So mostly when it came to criminal law, it was different because criminal law had this immense political implications, the sentencing of the opposition, of opponents to the regime, of, you know, all these very, very brutal death penalties in like minor cases of looting after air raids and so on. So there it was different, but also there, for example, the Greifswald court was never closed. It always worked. Like every day, a guy just walked in and was, emptying the post and seeing that everything is in order. Because this guy, more or less by chance, was not a party member. And so in the first months right after the occupation, a non-party member would be considered, unsuspicious, so he could just go on, and then denazification started, and then you would probably, inquire in more detail. But in general, it seemed to be a very dependent. Well, it seemed to be very much dependent on the individual situation in this individual place, so it's quite hard to generalize. But it would be too simple to just say there was no break at all. Many people didn't come back from the war, so obviously there was a break, and many couldn't just continue their service as a judge because they were politically so poisoned with everything they had done before that they could not just come back. And most of them, stayed out of office for 2 years, 3 years, and then came back. So it was, the break was cushioned in a way. So of course there were changes, but there was an instrument to keep up the illusion that everything just went on smoothly. And I think the illusion can be seen everywhere.
Before we go on with another question, I would like to pose my question because it's around the same topic. And at a certain point, you mentioned a case which started still during the war and ended in 1950 in, I think it was Eisenhüttenstadt.
That was Eisenach.
Eisenach, okay, but still the Soviet.
Yeah.
Soviet occupation zone. Which brings me to my question. Namely, was 1949 and the proclamation of the GDR a caesura?
This is one of the reasons why my study ends in 1948. Because my main idea was that the end of the war covers, when is the war over? It's a difficult question. In some areas, it takes decades for the war to be over. And maybe in some areas, it's not over today even. But one of the ideas I had was to depict the end of war as a long process starting in 1943 and reaching to the end of 1948, until it actually becomes clear that there is no shared Allied vision for Germany, that we're probably going to have 2 German states, and the new currency and all this, and the shadows of the constitution that you can already see, and so on and so forth. And this is why I ended in 1948. And yet, in this case, I was forced to go into the 50s because they were still suing and couldn't just finish up this case. And so I had to go until 1951. And in that respect, the founding of the GDR actually didn't change anything at all. There was this new generation of Volksrichter, people judges, this fast-track judges that came into office in 1946 mostly. So there was a generation of new personnel, but they also just went back, saw this record, saw, this is private law. What should I say? I just apply the rules of the civil code, and that's it. So
and the new personnel was educated still before 1945 or already after 1945?
Some so and some others. I think it took until 1953 until you had half. But I can't tell you about this exact case.
Because that's quite often the argument, that they were the same people educated in the old system.
Yes, but this is a very complex question. The new generation of GDR judges that came in were trained as, I think it's fair to say, political judges, good socialist judges, the working class, the farmers that could now enter this fast-track courses to become people's judges, Volksrichter, and then get into the courts. there they sort of had a peer system that they would get an older colleague to show them what to do, but not to show too much, because this older colleague was like a bourgeois guy. So, you know, you need to know how things work, but not too many things, because you need to be a socialist judge. And now they should do socialist law without having socialist norms. They still had the BGB, the Bürgerliche Gesetzbuch, the bourgeois law of the 19th century. And so in many of these cases that are actually past my study here, you see a deep desire of these people to be truly socialist, but they don't know what it means. And so they get all these marriage cases, all the divorce cases, and say, so what does Marx actually say? Should I divorce this marriage as a true socialist, or as a true socialist, should I keep up this marriage? I still don't know. And so it's interesting to see that they actually do struggle with the new times, and they do struggle with a new idea. They want to do something new, and they want to be really on the right side of history, but they still don't know how to decide this particular case.
My question goes back to this continuity hypothesis, and I wanted to ask whether you also came upon some specific cases that were filed because of the end of the war, as well before, because of the approaching end of the war, as well after, like not non-criminal cases, of course. After the war, you mentioned the one case with the divorce, where the wife wants to divorce the husband who deserted because that was shameful for her. But maybe there were also cases that, I don't know, somebody wanted to divorce immediately after the end of the war, or political reasons, I don't know. So is there other cases that can maybe now contradict the continuation hypothesis, or that also in this normal life for normal people, they use the civil law, or it wasn't true in this breach?
Yeah, that's a good point. I can't really answer because I wasn't doing this kind of research, but it's quite likely that you're right, that, you know, just as a Jew, you couldn't bring a lawsuit to court before 1945, and if you wanted to do that and were still alive, you could only do this after 1945. So obviously there is a break, because otherwise you wouldn't have had access to justice as a victim of Nazi persecution. But I can tell you, because I wasn't researching these cases, but yes, probably you're right. In that respect, there must be a break.
Hast du noch? Würde ich Andrew vielleicht, noch keine Frage gestellt? Andrew, jetzt noch an.
So I apologize if this is a little bit vaguely phrased, but I gather that when you talk about sort of a certain normality persisting throughout this period, it almost sounds like we're dealing with something that might be static, whereas of course, the law is also something that continually evolves, that sort of thing. Are there instances you ran across where there are sort of reinterpretations of precedent or changes of some kind or another that either carry forward or that are abandoned after the end of the war? Where are the sort of elements of dynamism that you see in this period?
Yes, there are these elements of dynamism. That is a good point, a good remark. For example, in marriage law. I mean, I'm talking a lot about divorces and marriages, not because it's so terribly interesting, but statistically, the judiciary in the past, I don't know, 2 or 3 years of the war is like a divorce machine. That's all they do. 80% of the cases they're dealing with are divorces. And the divorce rates are going up like this until about 1948 or 1949, and then it's like slowly declining. So most of what they're doing is actually divorce cases and a few of these tenancy cases. And there is a logic into that, because, right, housing is a problem when all the cities are bombed, and marriages are also a problem when all the male people are at the front. And in all these marriage cases until 1945, you have at least one obviously political implication that you can get a divorce when you have a marriage without children. Because the Führer asks for more children, you should produce more Germans, and if your wife can't do that, you can get a divorce. And that's a kind of argument you can bring into court after 1945. Plus all these, racial thought, if you doubt that your husband might have a Jewish ancestor and so on. So this doesn't work anymore afterwards. And again, yes, there is dynamic element into that.
I wanted to follow up on what you said first, that you wanted to write a social history of this time. And I suppose that one of the reasons the publisher didn't want the title to be proposed, that maybe it was too close to, or it would remind readers of Browning's book, and also in the meantime we have a book from the field of sociology of organizations called
Stefan Kühl.
Ordinary Organizations, Stefan Kühl, namely. So of course ordinary and normal course is not exactly the same thing, but I was wondering, listening to you, what actually is the normal here for the German society, because on the one hand it seems like it's just business as usual, so that's perhaps more on the argument of Stefan Kühl, but on the other hand, these reports you quoted, they show the authors as eager supporters of the system that go, way beyond what could be considered as business as usual. So I don't know what do you make with that? I don't know what to represent about that.
Yes, that's a good point. It's actually not normal to go into your court and first extinguish a fire, I guess. On a normal weekday, it doesn't happen, so this may be unnormal indeed. And I can tell you about my publisher. They wanted to have, one of the ideas I had was a quote. And since I have this long list of quotes of people who just write reports and say, legal operations were not interrupted, legal operation continued, blah, blah, blah. They chose one of these quotes and said that under our marketing strategy, this is good and promising. And I'm not an expert in this respect, so I can tell.
I had struggles with translating this to Polish.
Yes, I have Dienstbetrieb. I have.
So German.
It's so German, and I have struggles translating it into English as well. It's like legal operations and service and legal services. I don't know what would be a good translation. I think I was interested in showing that the normality they're purporting to keep up is, to contextualize it in these terribly abnormal times, and thereby showing that this normality is not, is guilty, it's morally poisoned, to say it again, that there is an evil in all this banality. It's not the banality of evil, it's the evil of banality that we see here. A deeply evil machine, I can't come up with other metaphors, that is built to keep up this entire illusion, to create the illusion of a stable, of a working, of a functioning society, everything is fine, and thereby being immensely political. And to show that even where they were just doing what they would always do, they were of great support for National Socialism, for the entire regime, to keep up the anti-war, the war society, and so on and so forth. And so in between, maybe it is rather on the side of Stefan Kühl than on Browning. But who am I to decide?
Another question.
There's a question in this direction. Why do the people accept this normality? Or are there defendants who say it's now not a system and we don't agree to this? We can accept what these churches say for the whole system? Or is it just so normal that you don't question?
Yes, it is so normal you don't question it. I mean, the huge campaign against this continuity started in the 60s, so much later, and it took until 1968, until anything politically happened to deal with this continuity, but after in 1945, I guess nobody actually questioned it. This is a very, very rarely. It's true. I found it for one court that one attorney wrote for his client saying, so now we're back here and we're facing again the same guy that we were facing before. And that was criminal justice. And that was a Sondergericht, a special court. So you would imagine, it is so obvious and so easy to dismiss this guy from office, and yet he was still there. And there it was bizarre because the entire personnel around was also there. The prosecutor was the same, the judge was the same, and one of the guys said, this is awkward, and again, everybody said, but that's how it is.
Can you follow up on that?
Yeah.
Because I remember from a very early court case against one of the staff members from one of the extermination camps, that when Jewish witnesses testified in court, that I came across it, but I'm not sure where it was, I think in Berlin. They discussed whether they can be sworn in because they weren't sure whether, because they are Jews, are they, when they swear to Christians, they will tell the truth. And can you believe that? Because perhaps their religion would allow them to lie under oath without any, because they are obliged under oath only to their brothers in faith. So with these Jews coming in now as a group of people that were not included in these proceedings before, do you see anything there that disrupts kind of this normality?
Are you asking when the German society stopped being anti-Semitic?
Good job, but how did they cover that up in court?
Yeah, you wouldn't argue openly anti-Semitic, but there are many ways to cover your anti-Semitism in other forms of legal argument, and that I'm not familiar with this case, I can tell you, but that sounds like
that's
legal reasoning.
An exception you didn't come across.
No. No.
Because
No, so sorry, no, I can't.
Because I'm not a legal expert, so I couldn't understand all this.
But did witnesses swear on the Bible before and after 1945?
Yes. I'm not sure if they actually physically swore on the Bible, but they would have to say, so help me God. I'm not sure when this practice ended. Now it's not mandatory anymore. You can still do it. But that is a much later development. Yeah, but so help me God, arguably you could say, so help me my Jewish God. But, but I'm not, I can tell you.
Apparently we have a vivid discussion.
Yes, my question regards to more maybe exceptions, so maybe you didn't cover them, but since the cases are still, or paragraphs are still highly politicized today, I wanted to ask about like the 218, so abortion, and 175, so male homosexuality, because they are traditionally also now discussed as continuities from the Prussian criminal code up until today, and of course also under National Socialism, but they were politicized both under National Socialism and also in the later on in the Western Germany, also Eastern German state. So what about those? I mean, those are criminal cases, but they are very politicized, but they were not revoked right after 45. So have you covered any examples of those or any arguments of continuations of those cases?
After the unconditional surrender, the Allied military government dealt with the problem what to do with all the Nazis and also with the Nazi law. And one solution would have been to just abandon everything and to start anew at the state of January 30th, 1933. And that was actually one of the ideas that they seriously discussed. But it soon became clear that this wouldn't work, because then you would have to revoke all the marriages and all the, tax records and what have you. So all administrative acts, all the houses that were built were illegal all of a sudden. So this doesn't work. And so the formula was that the law would stay what it was, with the exception of revoking everything that was that showed signs of National Socialist ideology. And then the discussion started, which parts of the law are actually National Socialist? And 175, the punishment of homosexuality, male homosexuality, is not National Socialist because it was there before. It was there in Weimar. Abortion, same story. Even and now I have to consider my English, the Erbgesundheitsgerichte and their judgments. So the sterilization of those that under National Socialist ideology were regarded racially unworthy, even those judgments were regarded valid because they were not National Socialist, because I think 26 states of the United States and Sweden and maybe Norway had similar laws. And so it took until 1998 until they were revoked. And so abortion is, in these standards, even not so political.
But wasn't it, if I can just follow up, wasn't it also argued, because you mentioned like the divorce reason of giving children to a Führer was not valid after the war anymore? Wasn't also one reasoning for keeping the abortion law so strict for the German inhabitants of the Reich, like this producing children, because if I'm correctly informed, it didn't apply to Polish women, for example, right? The abortion paragraph. So, but you still would say there was no discussion even on this politicized layer, because obviously there was a National Socialist layer.
No, there was no discussion on this layer, and I'm not too familiar with the history of abortion, I have to admit. But in terms of male homosexuality, there was a reform in 1935, which was National Socialist. And so the punishment itself was there before, or the paragraph was there before. But in 1935, it was severely stricter after this reform. And then they kept up the stricter version, which was actually clearly National Socialist. But since the punishment itself had been there before, you could argue, well, it's just random rule of law stuff. So we just keep it up.